Mr. Chairman, subject to any questions by anyone, I would respectfully reserve the opportunity to close.
Members, are questions, Mr. Spiller? Mr. Turner?
Thank you, Mr. Chairman. Thank you, Representative Spiller. So I want to walk through the bill, make sure I understand what it does and doesn't do. So right now, it's well established, a student and one can pray silently in school, right?
Correct.
That's the case today.
That's currently in the education code.
Okay. But, so this bill goes further in allowing, let me make sure I understand the process. So the bill would allow a school board or governing body of a charter to adopt a policy which would then require the schools in that district or the charter to set up this organized prayer or Bible study
Right.
time period? Is that
Correct.
Is that correct?
I think to answer your question, upon the effective date of this, if it passes, they would have, the school board or the governing body would have 6 months within which to have a vote at a public meeting and determine whether or not locally, if they decide to participate in this program or not. And if so, there are safeguards and statutory requirements and other things that would apply. And the specific wording of the statute, of the resolution is contained in the body of the bill. So they either choose to do that or they choose not to do that.
I appreciate that clarification. So it is their option whether to do it or not do it, but
Correct.
it is not an option whether or not they have the vote. They have
They
to make
would
a
have to,
decision.
that is
Have to have a
correct.
vote. Just like the chaplain measure from 2 years ago, right? That school districts had the option, but they had to actually have a vote whether to say yes or no to that.
One way or the other. Yeah, and it still is local control. They still decide whether they participate or they don't. But they are, yes, required to make that election within 6 months after it's passed.
Why make them have that vote? Why not just say, hey, this is an option, you can adopt this if you want to, but why force a school board to have a vote and vote yes or no?
Well, that's a fair question. I think it's because that many students want this opportunity. Many employees, others that work at the school might want this opportunity. And just to ask the school board to consider it is not unfair. It's not unreasonable to provide that opportunity if they choose to do so.
Sure, but the bill doesn't ask them to consider it, it forces them to consider it, right?
That's true.
Okay.
And that's the only really thing, aside from the guidelines and the rules set forth in the bill, that's the only thing that they're really mandated to do is every school district would make that election, would consider that at a public meeting within 6 months after it's adopted. That's correct.
Okay, thank you. So going forward from that part of the process, if a school board did choose to adopt this policy, what would it look like? So you have the school district says we're going to have a mandatory prayer period in school. And understand a student has the ability to opt in or opt out, right? With parental, basically the parents make the decision, is that right?
Right. Well, I think, let's back up.
Okay.
First of all, I would assume, and I'm thinking this from a school board trustee standpoint because I was on a school board before I got to this elected office and did so for 26 years. So I understand kind of the process. I would assume, and the bill talks about seeking guidance from the Attorney General's office, but it also, you adopt a policy of what that would be, either through the Attorney General based on their recommendations or based on what their local attorney or counsel would provide. And so through that, and I'm assuming also that there would be, many schools either go through TASB or through some other group to determine policy about what that looks like as far as the list of policies that they adopt, but they would have guidelines and more particulars about it. But through their counsel or the Attorney General's office, they would adopt that policy. And the policy would provide for It could be any number of things within the framework, because that's one thing that the bill doesn't really do is mandate exactly what this looks like. Presumably, it makes it very clear it doesn't take up instructional time. So unless you did it after school, it's possible you could do it during the school day, but sometimes that's somewhat problematic. I would think the thing that makes the most sense is do it before school, but the bill doesn't require that, as long as it doesn't take up instructional time. So you would do that. You would probably have a designated area for that, a particular classroom, depending how many wanted to participate. And there are safeguards in the bill that say that those folks that decide not to participate are not exposed to that. It's not within their hearing. It's not within their consideration. They're not forced or coerced or any way to participate in that. But the ones that do, either the employee, if it's a school employee, signs a waiver and signs this consent form, and the parent or guardian of the student would do likewise. And so that's generally, I think, how it would be set up.
Okay, thank you. So it could be before school, it could be after school, maybe during lunch
Could be,
or recess, maybe, I presume in younger grades, but not instructional time.
right.
Okay. Who would lead the prayer session?
I think that's a local decision. I think, and it doesn't necessarily have to be leading. It doesn't say leading. It could be student initiated. It could be something individual, where someone just comes in and has an opportunity to pray. Someone has an opportunity to read the Bible. Someone has an opportunity to read some other religious text, and that other religious text is not defined. That's a whole different issue. But I think it leaves, again, the school district the ability to determine what that looks like.
Okay. So it could be student-led, but it could be faculty-led. Is that right?
could.
A teacher, a principal could.
Could.
Okay. Could the school invite in a pastor or a clerical leader to?
I think they could. There are no restrictions in this bill on how it's implemented. So that's left to local school boards and local governing bodies of, when I say school boards, we all understand I'm talking about also from governing bodies of open enrollment or charter schools. But it's left at their discretion what they think works best locally. And if this is done daily, it may be a variety of those type things, I'm assuming. It might not just be one particular format. It may be different formats. I don't know.
Okay. So you mentioned, say, reading a Bible passage.
Sure.
Could you read a passage from the Quran?
You could.
Okay. There's nothing that prohibits
It
that.
just says religious text. It doesn't define what that is. And while I might not want to go to that and do that, the bill doesn't prohibit that.
Okay. Well, that gets to one of my concerns about the bill is, we have students in our public schools and charter schools of different religious faiths. Some are Christians. There are a lot of denominations within Christianity. Some are Jewish, some are Muslim, and some are other religions, some are not anything. And so how do you balance all of those different faiths that are present in our schools, just as they are across the state of Texas, and do something that's fair and not unintentionally discriminatory towards just people of other faiths?
And I think the beauty of this bill is that it's broad enough to where it allows local school districts, governing bodies, to make those determinations. And so you certainly locally, it could be that you may have a room over here of a certain faith and a different room over here of a certain faith. This bill doesn't prohibit that. It leaves it up to local control and local decisions to do that, to make those determinations policy-wise, what works best for that community. And we passed bills. We passed a lot of bills yesterday, and many of them, the last I checked, were mandates forcing things on local governmental entities. This, aside from the framework and aside from requiring them to have that election, this doesn't do that. It allows them to determine what's best for them under the framework of this bill.
So you could have under that scenario, so I represent Arlington School District, which is very diverse, and I know we have a lot of different religious faiths represented in our population. So you could have one Catholic student prayer or Bible study section. You could have another Protestant. You could have another Muslim and another Jewish. That could all happen within the same school on the same day.
Right. That's not prohibited under this bill. It's allowed, and again, the local, as long as it meets the framework of what's set forth in here and the safeguards there are, it doesn't restrict or dictate or mandate what that looks like. So this is drafted in a way, in light of current federal law and state law under the Kennedy case and things that have been looked at. That's why it's drafted the way that it is. So yes, I think those scenarios that you described, I think those are absolutely permitted.
Okay. So you mentioned the Kennedy case. So I want to talk about the constitutionality of this. How do you see this measure being in alignment with the First Amendment of the Constitution that prohibits the establishment of religion?
Well, I think it's absolutely permitted, and I think it's in line with the Kennedy case, the 2022 case that overturned the Lemon case and the Lemon prong, the three-prong test in the Lemon case back in 1971. Many have taken the position for a long time that was wrongly decided. I was 10 years old at the time. It probably took me a little bit longer before I came to that determination, but nonetheless, I didn't necessarily agree with that. And so I think the Kennedy case is the proper ruling that that it's based on historical and other factors rather than the prongs set forth in the Lemon case.
Well, in the Kennedy case, if I recall, involved a coach who was praying silently, I believe, at football games,
Right,
as I recall.
after game.
Right, okay. So, but this isn't one person voluntarily, deciding to pray silently. This is the school, by extension the government, actually organizing prayer and organizing Bible study.
I don't know that I wouldn't call it organizing, they're allowing it. And as we say, that's,
The board would adopt a policy to require the schools in their district to do it. That sounds like organizing it to me.
well, I think that's left locally to decide, but there's no coercion, there's no dictating, there's no required participation. Everyone that participates, they either do or they don't. And if they do, then that's their choice to do so. And if they choose not to do so, they can choose that as well.
Are you familiar with a 2024 federal case out of Florida involving, I forget the name of the case, City of Ocala? It's Rojas and Hale plaintiffs versus City of Ocala.
I've read several cases, that's not one of them, so.
Okay. Well, in that case, and this was decided after the Kennedy decision, and the decision references the Kennedy case throughout, but basically the federal court in this case, and this again was just last year, came to the conclusion that where the city was organizing through the police department a religious event, and well intended. But basically, the argument from the plaintiffs was that city employees and citizens felt coerced to attend, coerced to participate, and it's a long opinion. I won't go through the whole thing with respect to time, but essentially, the federal court in that case concluded that, and they referenced the Kennedy decision as Kennedy commands. The court bases its decision on a, quote, historically sensitive understanding of the Establishment Clause, and comes to this conclusion, again, the Florida case, where government action amounts to sponsorship or favoritism towards a religious belief system, it violates the Establishment Clause. That's what happened here. It just seems to me like there's a lot of parallels between where this legislation may go in our public schools, in this case out of Florida. Again, that was decided after the Kennedy decision. So my concern is that this goes far beyond what the Supreme Court sanctioned in the Kennedy case.
And I'd be happy to look at that if you want to later provide me offline, provide me
I'd be
with
happy
the
to.
site to it. And did that make it to the U.S. Supreme Court, or was that a district court case or circuit court?
It
you
was in
recall.
United States District Court.
Okay.
And so, and again, it was just decided last year, so I don't think it's made it to the Supreme Court yet. I don't know if it's been appealed, actually. But I can find that out, but happy to discuss it more. with
I'd
you
be
later.
interested, sure.
I think that's the concern, and I think fundamentally, even though this is voluntary, if a student or their parent opts them out or doesn't opt them in, my concern would be peer pressure from fellow students, which could amount to coercion to participate. Just, there's a lot of peer pressure for different reasons in school, and my fear is that could lead to coercion
Well,
to
I think
participate in this.
Probably practically the greatest threat of coercion would be those that decide to opt in and the parents allow them to, if it's before school, would be the coercion from parent to child to say, you might better get on up and get to school because you've got that in 5 minutes beforehand rather than at the regular time. So, but I get the concern.
Okay, thank you for the discussion.